Hey everybody, this is disability attorney Michael Einer. This is a different kind of video for me to shoot. Usually when I'm talking to you about a specific case, I'm talking to you about a case that I won, which isn't to sound braggy. We win a lot of cases. But in this case, in this video, it's different because I'm actually going to be talking to you about an unfavorable decision that I received in the mail. And I'm mad. I'm frustrated, okay? Because this decision just feels unfair to me. Let me tell you why. This particular client of mine had a very strong work history, a proud woman, was working through her pain. She has fibromyalgia and a lot of mental impairments, but that didn't stop her from continuing to work for many years, was always treating with doctors, but kept up at work, did the best that she could until it just became too much, okay? She applies for disability, and like most of the people that we represent, unfortunately, at the beginning of her case, she was denied. The medical experts for Social Security who reviewed her case, said that she could do a very limited range of work, but said that, she would require the use of a cane or a walker for ambulation, said that she would be able to interact with the public and coworkers, but only occasionally, said that, her ability to deal with the pace of a job would be very limited. Some pretty significant restrictions when you think about the type of work that's out there. But nevertheless, they denied her case. Very typical. And as we always tell people, don't give up, keep filing appeals. So we did. And in the meantime, we kept developing the medical evidence. And her condition continued to deteriorate. We got all of her medical records. We got multiple opinions from her treating providers, which were supportive of disability and the fact that she would not be able to work full time. So we had her hearing, okay? And at the hearing, the judge that she was assigned to, who happens to be the lowest granting judge that we have here in Cleveland, did something that to me is just absolutely despicable. Even though my client had been found by Social Security's own medical experts to have the limitations that I described earlier, okay? And the medical records would show that she was even more limited than that, and her condition had only gotten worse in the time since her case was last reviewed. The judge, in order to just find a reason to deny the case, loosened up the restrictions to allow the vocational expert to find jobs. Because when I asked the vocational expert whether or not somebody would be able to work with the exact limitations that the medical expert employed by Social Security to evaluate my client's claim would have, the vocational expert retained by Social Security, retained by that judge, said that there was no work at all that my client would be able to do. So what do we do? How do we defeat this? Let me tell you what we do at Liner Legal. At Liner Legal, we warrior up because we're disability warriors, okay? And I'm not going to let somebody pick on my clients. There's an appeals process. I'm going to file her appeal to the appeals council. If I have to, I'll file her case into federal court. This client is not unlike so many other clients of mine and every other attorney who get denied benefits by unfair judges who care about nothing more than what they think is protecting the disability trust. And I'm sick of it. And I'm going to do everything that I can to pursue justice for this client, for every other client I have that gets unfairly denied, to make sure that she gets another hearing, a fair hearing. And in the end, we will prevail. We will find a way to help this client. And even if it takes time, I know that she knows that I'm fighting hard right next to her.